This Module 7 lecture reviews legal analysis. What is the purpose of legal research and analysis? The purpose of legal research and analysis is to learn and then report what the law is so that knowledge can be used to resolve conflicts which arise in analogous, but usually somewhat different, fact situations. The purpose of legal research and analysis is not to find a definitive answer to a question and report on it. It is much more nuanced than that. Rarely is there a legal question that can be answered definitively. Legal analysis is very fact-specific. This means that each small fact is going to impact your legal analysis. Let's go back to our client from an early. Let's take a look at how some of the facts in this fact pattern might result in a different legal analysis if they were to be changed. How about LM's age? In this fact pattern, she's 22. But would it be different if LM were under 18? Of course it would impact the legal analysis because LM could not be bound to a contract if she were under 18 years old. It also may impact some of her liability in a situation. How about the fact of LM's cousin's misdemeanor? Right now, she has a misdemeanor for jaywalking. But what if LM's cousin had some sort of conviction for drug sales or drug use? That would definitely change our fact pattern, as when we look as to whether or not LM knew or should have known that her cousin had, would participate in criminal activity, I think there would be a different analysis about what LM should have known if her cousin had the conviction for jaywalking versus what LM should have known if her cousin had a conviction for prior drug possession or selling of drugs. Obviously, the fact that LM was aware of any conviction of her cousin is important. If she was not aware, then clearly she would not have known or had reason to know that her cousin would participate in criminal activity. These are all the way that facts, small facts, can change your legal analysis and change the type of law, or not necessarily the type of law, but the outcome of legal opinions based on the situation that your client is dealing with. Legal research is a process. And like any process, there are some steps that you can follow to get you started along the correct path. Step 1. State the issue or issues in the case. It is imperative that you understand what legal question you have to answer. If you find that you are struggling with the issue, do not be afraid to ask your attorney or senior paralegal for guidance. Without knowing your issue, you are unlikely to be completing the correct research, thus wasting your and your attorney's time. The first step is stating the issue. The second step is conducting the research. But where do you start? You can begin on the internet, but you can't end there. You can use general information available on the internet to help you focus your research, but then you have to move on to platforms that are specific to legal research. Therefore, you want to use your primary sources of law to analyze your issue on Westlaw or Lexis or other legal research platforms. When we talk about primary sources of law, we're talking about statutes, constitutions, administrative laws, and judicial opinions. Primary sources of law must be followed by courts within each jurisdiction. This is because of stare decisis, which means it stands decided. It applies only to published decisions that come from appellate or supreme courts, to cases within the same jurisdiction, and courts must follow cases of higher courts unless the facts are distinguishable. In addition to using primary sources of law, you want to use current law. While certain older judicial opinions are important in either an historical context or because the law as stated is still legal precedent, the paralegal should always try to find more recent law that supports the older proposition to include in their memo. Now let's move on to step 3. Step 3 is describing the current law. You want to describe what the law is based on your research. Cite the research appropriately and restate its holding. This is where drafting the case brief using an IRAC comes in handy. You will find that you will use the IRAC consistently throughout your academic and legal careers. Step 4 is to apply the law to the fact situation of your client's case, stating the probable outcome of the case. On to step 5. Step 5 is to identify distinguishing facts between the case you're analyzing and your client's case. Describe differences between the fact situation you are analyzing and the fact situation in the cases you cited, which might lead to a different outcome than what you had originally indicated in step 4. The final step in the process, step 6, is to conclude your analysis. Discuss the fundamental nature of the legal conflict, residual issues involved, and what your research of the law indicates for the facts in front of you. Do not try to find a conclusion that fits the outcome you think your attorney or your client wants. You want to find a conclusion based on the research that you conducted.